Hi, welcome to International Law of the Sea. I'm James Kraska. This presentation will discuss the Bering Sea First Seal Arbitration of 1893. This case is important because it presages the development of the exclusive economic zone. It highlights the problem of the tragedy of the commons on the high seas. And it focuses on the origins and the legal rules for the conservation and management of marine resources today, especially marine mammals. So the case focuses on the legality of pelagic sealing beyond the borders of the territorial sea. Pelagic meaning taking seals on the high seas. These were fur seals that inhabited Pribilof Islands, which are located some 500 miles northwest of the Aleutian Islands. These islands were owned by the United States. They were acquired along with Alaska and the Aleutian Islands on 30th of March in 1867. Now, until that time, the Russians and also the United States had managed the stock of fur seals by taking only males and taking the seals on the island. They were clubbed to death. They were bludgeoned. They were herded into a designated area and harvested. But in this way, the United States was able to maintain the size of the stock. Well, soon after, British sealers, British flagged Canadian ships, began to intercept and shoot seals on the high seas, beyond the territorial sea of Pribilof Islands, outside of the United States jurisdiction. In response, the US Navy boarded and seized a number of these Canadian ships, and that led to, in 1886, a treaty to submit the dispute to arbitration between the United States and Great Britain. And so a tribunal was legally constituted in order to resolve this dispute. By 1890, there were just 959,000 fur seals on Pribilof Islands, yet this was down about 2/3 from 1874, so down about 66%. The Canadians hunted the seals at sea by shooting them or spearing them with harpoons in the water. But this was a very wasteful, inefficient way to harvest the seals, because 6 or 8 seals were killed for every one animal that was successfully taken on board the ship. They were just lost at sea. Canada disputed the right of the United States to board their ships and seize their vessels in international waters. And so they appealed to Great Britain to help to resolve the case. In the proceedings before the tribunal, the United States claimed that Russia had exercised exclusive jurisdiction in this area before it conveyed the islands to the United States, and so the United States simply acquired that jurisdiction when it purchased Alaska. The United States also argued that even if US jurisdiction had not existed previously because of inheriting the Russian jurisdiction, that the United States had a title or a property interest in the fur seals inhabiting the islands, even when they left US jurisdiction, and that measures were needed to protect the stock of seals, the population of seals, and that the most effective way to prevent them from annihilation was to ensure that they were under US custodianship jurisdiction. But the arbitration ruled that the fur seals were caught outside of US jurisdiction, and that therefore the United States had no exclusive property rights in them. In its award, the tribunal found that the US had no exclusive jurisdiction over Bering Sea fur seals outside of the territorial waters. It rejected this theory of custodianship that the United States had suggested, and it upheld the doctrine of the freedom of the seas. The tribunal ruled that seizing Canadian ships on the high seas constituted an unlawful act for which the United States bore legal responsibility in international law. Having said that, the tribunal also recognized that there was a need for protection and preservation of the fur seal population. And so toward this end, it laid down a mandate in the compromise that it adopted that included several regulations that helped to protect the fur seals. First, it recognized a no sealing zone around the Pribilof Islands. It also adopted an annual closed season for pelagic sealing in the area, and it prohibited the use of certain methodologies for taking seals, including nets, firearms, and explosives. Interestingly, it also recognized an exemption for aboriginal sealing, and this has been carried into the present through recognition of Native American rights in North America, as well as Aboriginal native rights to marine resources in the Arctic Ocean generally. The exemption for Aboriginal pelagic sealing also foretold a similar exemption in the International Convention on the Regulation of Whaling. Finally, some 18 years later, in 1911, a further international agreement banned pelagic sealing completely, and that ultimately led to the recovery of the population. And that multilateral agreement also included Russia and other regional states.